Hello, law students, advocates who are practicing throughout Indian courts, respected judges, and the judiciary aspirants. Let's today discuss about the admissibility and relevancy of the digital evidence or the electronic evidence in Indian courts. What is the law for that? The present law is Section 63 of the Bharatiya Sakshi Adhiniyam. Earlier, the law was Section 65B of the Indian Evidence Act. Basically, the digital evidence or electronic evidence means the emails, the Facebook messages, the WhatsApp chats, and various photos and videos on the social media, which can become a very important piece of evidence in a particular case, in a particular trial, whether it's criminal or civil. So, while tendering that evidence, the court would have kept in mind, or basically it was mandatory under Section 65B, that it is not fake, it is not procured fakely, or it is not tampered with, it is not tempered. So for that, a certificate requirement was essential, mandatory, and that certificate would authenticate that particular piece of digital evidence to be totally correct. And that certificate was procured from digital expert or IT expert of that particular area, and he will authenticate that this particular digital evidence or the electronic evidence is totally correct, and whatever is depicted in that particular evidence, it is reliable. So that reliability factor has been totally determined by that particular certificate, which has to be produced before the court, and until and unless that particular certificate from the digital expert or the IT expert, and that certificate is having proper format also, so without that certificate, the court will not decide the case. And it was a lot of harassment for different people or stakeholders in that particular case, because without that certificate, it was a very technical issue. Without the certificate, because certificate was not easily available at that point of time, even now also, so there was a lot of delay in deciding the cases. But and even at that point of time, during Indian Evidence Act, the this digital evidence or electronic evidence, whatever, though it was a part of the documentary evidence, but it was not regarded the status of the primary evidence. It was regarded the status of secondary evidence. It was the secondary evidence, and it was not primary evidence. It was not the original evidence, as the court would say. So the court would usually need a certificate for that, and because it's not a primary evidence, it was not given due importance at that point of time. But because of changed circumstances, because of the IT revolution, the law has been changed. Now under Bharatiya Sakshi Adhiniyam, under Section 63, primary status has been given to this digital evidence or the second electronic evidence. So it's no more the secondary evidence, it's the primary evidence. But the thing is that the certificate requirement is still there under Section 63. Certificate requirement is still there, but it's the discretion of the court in which cases the court will ask for certificates or not. It's the discretion of the court. Basically, under Section 63, Clause 3, if the particular person who produced the certificate or not certificate, the particular person or the party who produces that digital evidence or electronic evidence, he orally testifies about the authenticity of that particular digital evidence, then it's more than enough. He should give affidavit about the authenticity of that digital evidence, that the court will obviously affirm that it's basically true, and court will take it as evidence. So, but in case if the other party says that no, we will not accept this thing without cross-examining the person who has produced that evidence, and they say that certificate is needed, without certificate we will not be allowing this evidence to be tendered before the court, and the court also asks for the certificate, then the certificate requirement is there, because it has not done away with. It has not been done away with. Still, the certificate requirement is there, but there's ease of this thing, because the court instead of totally relying on the certificate, court can use its own discretion in finding out whether the digital evidence or the particular electronic evidence is true or false. For that, the court can itself distinguish between the true or the false thing, and for that it can see the particular digital evidence itself. The Supreme Court also in Anwar PV versus PK Bashir 2014 case ruled that the certificate requirement was sine qua non, that is essential condition for admissibility in the court of law. Without the certificate, electronic evidence or the digital evidence was inadmissible even if relevant. The courts often earlier rejected evidence because the certificate was missing or the certificate was defective. So at that point of time, there was a lot of delay. Under Section 63, the certificate requirement is still there, but it is the discretion of the court. Because if the other party or the court itself sees into the case that the case is very important, it is very technical, and it involves very important piece of evidence, then the court can ask the parties to bring the certificate along with their cases, and they need not to bring the certificate during the time of the initial filing of the case, but they have to bring during the trial phase, during the tendering of the evidence. So this was the case. So during the trial phase, whenever the party proposes to bring its digital evidence before the court, at that point of time, the party has to bring the certificate along with the digital evidence at the time of the trial. So that to authenticate that the digital evidence is totally correct evidence. Then later in Arjun Pandit Rao Khotkar versus Kailash Koshan Rao Goriantal 2020 case, the Supreme Court reaffirmed this thing but allowed some flexibility that certificate could be produced later or via affidavit in a certain case. So the requirement of the certificate to be filed initially under Section 65B, that was done away with under this Arjun Pandit Rao Khotkar. Now the party can file the case, but in case the court needs the certificate requirement is still there, but it is simplified. The court doesn't pay emphasis on the initial requirement of certificate during the initial filing of the case, and the court can ask for the certificate during the trial, during the time when the parties tender the digital evidence. So along the tendering of the digital evidence, they have to produce the certificate before the court. This is the present law under Section 63 clause 4 of the Bharati Sakshi Adhinam. There is a recent case also in which the Supreme Court said that the CCTV footage is a very good piece of evidence as far as the trial is concerned, and the case is Sudham Sanap versus State of Maharashtra 2024. So the court says that CCTV footage or the video evidence of that particular thing is the sole evidence. If it's the sole evidence and there is no eyewitness also, then that evidence is reliable and a proper certification is needed. If it is reliable and certificate is also given about that evidence, then the court can totally rely on that particular piece of evidence. So nowadays under Bharati Sakshi Adhinam, whenever the advocate presents his digital evidence or electronic evidence before the court in proving his case, the other party or the other advocate who is opposing this digital evidence, he can point out that that particular certificate is not there, and that digital evidence or the electronic evidence which is tendered by the opposite party, it has to be along with the certificate. So certificate requirement is still there, and the other party can ask for the certificate, and the court can even ask for the certificate. So this is the present law. But again, I am saying that if the party is producing the digital evidence or the electronic evidence, that is the photo or video or email or WhatsApp chat or whatever social media content, then if the court says that it is from the original source and court sees that it is from the original source, the court, instead of requiring a certificate, can ask the party to testify whether it's true or false under Section 63 clause 3 of the Bharati Sakshi Adhinam. So under Section 63 clause 3 of the Bharati Sakshi Adhinam, the court can ask the person who has the proper custody of that digital evidence to testify before the court that it is correct, it is authentic or not. And if the court sees after the testification from or the person who is testifying before the court that it is totally correct, court will take his affidavit, the court can proceed with the case. Court will not require the person to produce the certificate. So this has been now the present trend, and the judicial officers throughout India are following this trend. And in every case, certificate requirement is not there. Only in important cases in which there is a lot of suspicion and there's a lot of technicality involved, a lot of important things are involved in a particular case, and that point of time, or in that case, the court can ask for the certificate. In the case of Tommaso Bruno versus State of UP 2015, video evidence was held inadmissible without proof of source and integrity. So this highlights the ongoing need for the certification under the Bharatiya Sakshi Adhiniyam. So in this case, video evidence was not admissible, was held to be not admissible without the proof of the source of that evidence. Then there is the case of Shafi Muhammad versus State of Himachal Pradesh 2018. Way back when there was this Indian Evidence Act 1872. This is not the present case. In earlier, during the Indian Evidence Act, when there was the certificate requirement mandatory under Section 65B. So this case, Shafi Muhammad case, in this case, Supreme Court allowed the provisional admission of electronic evidence, that is CCTV footage or video, without immediate certificate, influencing BSA's pragmatic approach. So in this case, way in 2018, there was the pragmatic approach in this case by the Supreme Court, and the Supreme Court allowed the digital evidence without the valid certificate. So at that point of time also in 2018, in this particular case, the Supreme Court said there is no requirement of certificate during the initial filing of the case. It can be procured later on. So at the end, the law is that the certificate requirement is still there, but in particular cases only. And what particular cases? In which there is a lot of digital and electronic evidence out there. The case is very complex and the whole case is dependent on the digital or the electronic evidence. The court will, in order to authenticate that particular piece of digital evidence or electronic evidence, the court will ask the party who is tendering that digital evidence to produce the relevant certificate of authentication, and that certificate can be from the IT expert or the digital expert of the area, or from the person from whose custody that particular evidence is being given. The particular person who is having the custody of that mobile device or the electronic device or the digital device or the computer chip or the semiconductor chip, he has to give the certificate along with his signature and authentication that this data or the particular thing which I am producing is totally correct and it is not fake. So all these things are needed in the certificate. Particular format is being given in the certificate. In that format, the certificate is needed for the digital evidence. So, but the court still has the discretion now. Earlier, under this Indian Evidence Act, the court didn't have the discretion. Now it's the discretion of the court whether the certificate is needed or not. The court can ask the party to bring the certificate along with the tendering of the evidence, or the court can say that you need not to bring the certificate because the evidence seems to be totally reliable and it's not fake, it's totally authentic. So it's a sole discretion of the judge, but in particular cases the court can ask for. So the requirement of the certificate is still there, but it's not as mandatory as it was earlier. Still, the Supreme Court cases are there which can be coming in future, and let's see what the Supreme Court decides in this particular area of digital evidence, because I think a lot of cases may be pending in Supreme Court and further judicial pronouncements are awaited regarding this clarity of digital evidence and electronic evidence. Thank you very much.